The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. Any persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you, Madam Clerk. Our first case today is number 20-6426, Horner versus Nines. Mr. Jawar?
Yes, Your Honor.
You have the floor, sir. You represent the state of Maryland, the Attorney General, correct?
That is correct, Your Honor.
Good to have you with us, sir.
Thank you. Good afternoon to you all. I do represent the respondents, appellants in this case, which I'll collectively refer to as the state of Maryland for convenience. In this case, the district court's decision to award a writ of habeas corpus to Matthew Horner on the grounds that Maryland's courts unreasonably applied Supreme Court precedent to reject his jury trial waiver and Brady challenges was a mistake under EDPA. The district court did not assess Horner's claims with the appropriate amount of deference. At various junctures, the court did not focus on the last reason state court decision, did not give the state courts the wide berth they were entitled to in applying generalized Supreme Court standards, and purported to reject the state court's credibility findings. This was no more obvious and pronounced than the decision to credit a different set of competing post-trial witness affidavits than had the state post-conviction court. And the district court did this without seeing any of these witnesses. Given the number of grounds that the court decided below, there's a wide field of play that we could cover, and I don't suspect that I'll be able to address each equally, but I want to be as useful to the court as possible. Unless the court has specific concerns, which I'm more than happy to prioritize, I would like to suggest that perhaps we focus on the Brady and procedural default issues, since they might benefit most from a clarifying conversation.
Well, you can do it however you want to do it. This is Judge King. But I have some concerns about the waiver of the jury issue. I'll just alert you to that. So you frame it however you want to do it. And my colleagues may have more specific concerns than I have. Go right ahead. Okay,
well, I'll start there then, Your Honor. The jury trial waiver in this case was not, or at least the Court of Special Appeals affirmance of it was not contrary to Zerbst in an objectively unreasonable manner. First of all, I think the district court got hung up on some dicta in Patton to condemn essentially the colloquy, the solemnity of the colloquy, which was really not the proper focus, since there really is no constitutional right to an on-the-record colloquy. Of course, we all know that such colloquies occur as a matter of course across the nation. They are required by court rules or case law, but there is no constitutional right to an on-the-record colloquy. So to say—
What is there? There's a constitutional right to the defendant making an express intelligent consent, is there not?
There is, Your Honor.
And that, you said that the dicta thing, and that's what you have in your brief. And I just hope, and that was the very thing I had open here, because they say that in Adams, a few years after Patton, which you said was dicta, but this thing was dicta, the Supreme Court said, and they quote, unless they quote it wrong, citing Patton, "We have already held that one charged with a serious federal crime may dispense with his constitutional right to jury trial where this action is taken with his express intelligent consent." Now they use the word held in Adams, and you say it's dicta. So how do you get around what way the Supreme Court characterized it? Is that dicta too?
No, Your Honor, we do not disagree that the waiver must be knowing, intelligent, and voluntary. What we are saying, though, is
And you
that,
agree the patent held that?
well, we agree that Zerbst held that, and that was the claim.
Well, they
that was,
cite the Supreme Court in Adams cited patent, and they called it a holding. At least they said held. I assume that's a holding. I just couldn't understand. I don't know why you get into things like that. I mean, you've got a pretty good argument on this EDPA stuff, and then you get off like that.
Well, Your Honor, our point is that dicta is not something that the district court, could use to condemn the waiver. There is a difference between the constitutional validity of the waiver, which Zerbst says must be knowing and intelligent, and the quality of the colloquy and the content that must be in it. So the district court focused on the colloquy, which is dicta at best from the last paragraph of patent only. There is a holding in patent which deals with the knowing and voluntary law that must apply to the waiver. We don't dispute that, but the court didn't use that part of patent. It used the last paragraph, which discussed the nature of the inquiry. And in Zerbst, the court made very, very clear that what is fitting and appropriate, which is all that the court said with regard to an on-the-record colloquy, is that it is fitting and appropriate, but it's not required as a constitutional matter. In fact, this court said in Kahn, which we've cited in our brief, that the colloquy it's not itself a constitutional requirement. So the court below focused on the last paragraph of patent. That part is dicta. There are other holdings in patent which are good law, and they're echoed by Adams and they're echoed by Zerbst. But we think that what the court did here was get confused between the waiver, examining the waiver, testing the waiver, and testing the nature of the colloquy and whether it was sufficiently solemn. The court said it was lip service, it was rote. But really, when you're the petitioner on collateral review, it is your obligation to show that you did not knowingly and intelligently waive. And the district court didn't engage that discussion. It relied entirely on its assessment of the colloquy.
Do we give any deference to what the district court did?
No, not in terms of the AEDPA analysis, not at all. Your review is de novo.
No, we're looking at it de novo, aren't we? So we got to go right to that. We got to go right to that record and figure it out under the authorities that you have just talked about, which they talk about too, Patton and Zerbst and Adams.
That's right, Your Honor.
That's what we got to figure it out for ourselves. We don't give any deference to what the district court said or did. Go right ahead.
Yes, Counsel, Counsel, this is Judge Quattlebaum. I have a question. If y'all are through for the time being on the jury trial, Judge King, if you have follow up on that, I'm glad to hold off.
No, I'm fine. You go right ahead, Judge Quattlebaum. I'm sorry I took too much, maybe.
No, that's great. That was helpful. Counsel, I want to switch gears and talk about the Brady violation on the issue of whether Schaefer was a paid informant. And my question relates to information that the prosecutor learned during Schaefer's sentencing. And my question is whether that actual knowledge claim, based on what happened at the petition, was raised in the habeas petition. The district court didn't address it. And so was it raised in the petition, the habeas petition?
No, Your Honor. The habeas petition that's been filed 3 times over, meaning we have an original, an amended, and a second amended, does not raise that particular claim. And I would point out that it was raised by previous post-conviction counsel in the 2010 UPPA, post-conviction, it's a Uniform Post-Conviction Procedure Act in Maryland, the UPPA court, but it was not the focus. It was procedurally defaulted because it was not made the subject of an application for leave to appeal to the Court of Special Appeals. And I can only take it for that reason that it was not, appropriately so, not raised in the habeas petition.
Okay. All right. And I want to switch gears with one other question about that issue. When I say that issue, I mean the paid informant question as a whole. One of the things we have to look at is materiality, and the district court considered materiality collectively, if you will, or cumulatively, and we don't. But the district court. And so, how do we deal with materiality? Do we deal with it on an issue by issue basis? For example, do we look at materiality on this one Brady claim kind of in isolation, or do we do it, or does the district court's determination on a cumulative basis bind us? How I guess since it's de novo, you think we could do it, individually, issue by issue, right?
Well, Brady law, Your Honor, directs that materiality is assessed cumulatively based on the total effect of each suppressed item's finding. So the thing that you need to do first is determine how many pieces of evidence are suppressed. And then you look through materiality as a whole. You don't isolate it piece by piece. The problem,
so if for example, hypothetically, we thought that was the only potential Brady issue, we would look at that issue as the only one, since it's the only one suppressed. But if we found more than one, we'd look at them cumulatively, correct?
That is correct, Your Honor. That is the state's understanding of Brady materiality law. The difficulty of the record, at least, and you are correct, you are to determine that afresh. You're not bound by the district court's reasoning, but I have to say that the district court did not really treat this part of the UPPA court's legal reasoning distinctly. There's a portion of the opinion below that sort of mushes together after rejecting some of our procedural default arguments on some of the individual Brady claims, but then just sort of assumes that all of it's been suppressed without discussing it and doesn't really identify what things the court is considered suppressed. So you kind of wind up with this materiality discussion that acts as if it's all suppressed. And we certainly disagree with that. Had the court itemized its opinion a bit clearer, we might know precisely which things it considered in its materiality discussion, but that's not clear.
Thank you.
I see that my time is drawing nigh. I have about 2 minutes left. I think I will, at this point, yield.
Very good. Judge Traxler, Judge Quattlebaum, y'all got any further questions before you yield?
I have no questions.
I have none right now. Thank you, Judge Kane.
Very good. So we'll hear from counsel for Mr. Horner. And that's Mr. Naples.
Thank you, Your Honor.
Naples, good to have you with us, sir.
Good to be here, Your Honors. Thank you. Good afternoon, and may it please the court. My name is Pascal Naples, and I represent the appellee, Matthew Horner. In this case, the district court correctly held that Mr. Horner has wrongly served 15 years because of a constitutionally defective trial. In particular, the district court concluded that the state contravened Brady in failing to disclose 6 different pieces of exculpatory evidence related to the state's only 2 key witnesses at trial. In addition, the district court ruled that the record did not establish that Mr. Horner knowingly, voluntarily, and intelligently waived his right to a jury trial. As to the first Brady claim, the Supreme Court in Kiles versus Whitley held that information known to the prosecution, including the police, must be disclosed to the defense. And the district court properly concluded that the first state PCR court unreasonably applied Kiles in holding that information known to a detective, Detective Hahn, regarding Mr. Schaefer's longstanding relationship with the police need not be disclosed to the defense. In particular, Detective Hahn testified at JA 347 that he received a call from Richard Schaefer regarding his intent to provide information about Mr. Horner. Detective Hahn then called the lead detective in the case, Detective Alex, then attended the first meeting between Detective Alex and Richard Schaefer, and then acknowledged that he was aware that Richard Schaefer was asking for a sentencing reduction in exchange for his testimony. On this record, it was objectively unreasonable to conclude under Kiles that the information known to Detective Hahn could not be imputed to the prosecution. But in this case, the record before the district court was actually broader than it was before that of the first state PCR court. And therefore, this court, consistent with Monroe v. Angelone, can look de novo to the information that's before the court and assess the scope of Detective Hahn's knowledge and whether that has to be imputed to the prosecution. In particular,
this is Judge Traxler. Can I ask you a question? What extra information is there that's before the federal court, this federal district court, that was not before the state court?
At the second round of post-conviction hearings, Your Honor, Prosecutor Jennifer Schiffer testified at JA 2214 that she knew that Schaefer had a pre-existing relationship with another detective. And at JA 2149, Detective Alex testified that he knew that Schaefer was a paid informant. Now, the second state PCR court did not reopen Horner's Brady claims and therefore did not assess the imputation conclusion reached by the first state PCR court. So effectively, the federal district court and this court are the first courts to review the imputation claim in light of that testimony at the second PCR hearing. This information—
I understand what you're saying.
Okay.
And you say that, so you say that scenario undercuts the application of the AEDPA standard.
That's correct, Your Honor. And that's consistent with this court's decision in Monroe v. Angelone when there's new evidence that has not been subject to a pre-existing state court determination, then it's incumbent upon the court to review that information de novo. Now, initially, under this set of facts, it's an unreasonable application of Kiles to hold that Detective Hahn's knowledge cannot be imputed to the prosecution. But certainly, in light of the information established at the second round of PCR hearings, namely the testimony of Detective Alex and Prosecutor Jennifer Schiffer, the information of Detective Hahn could be imputed to the prosecution. And that information, this long-standing relationship between Detective Hahn and Mr. Richard Schaefer, a decade-plus paid informant relationship, was alone material to the verdict and undermines confidence in that verdict. This is not a case in which there's a blank jury verdict in which this court has to guess at whether a determination was material or what motivated the jury's determination. Here, the judge said, the trial judge at JA 1021, that he paid, quote, particular attention to Schaefer's testimony. And Prosecutor Keith Pion emphasized at JA 1004, quote, he came to us without any kind of deal or offer. And Schaefer testified merely that he had provided information to a narcotics detective maybe 10 times and never received leniency or consideration in exchange for his testimony. That's at JA 1391. Of course, this court now knows that Schaefer had a decade-plus relationship with Detective Hahn, that he called Detective Hahn whenever he was arrested, and that charges were null prossed in exchange for information provided, and that he was paid hundreds of dollars on multiple occasions in exchange for his testimony. And while that's what Richard Schaefer testified to at the second round of post-conviction hearings at JA 1151 through 1153, you need not take Richard Schaefer's word for it. Detective Hahn admitted at JA 332 through 34 that Richard Schaefer called him looking for assistance in connection with arrests in both 2002 and 2004. In short, this Brady claim alone establishes that Richard Schaefer was not an occasional cooperator, but a professional witness who had a revolving door relationship with the police in this case. And given the reliance that the trial judge placed upon Richard Schaefer's testimony, that alone is sufficient to undermine confidence in the verdict and provide a basis for habeas relief. But it's not just the paid informant relationship that undermines Richard Schaefer's testimony. It's also the fact, as revealed by Detective Alex in his second round of post-conviction testimony at JA 2156 through 57, that he investigated allegations that Richard Schaefer levied against Mr. Horner about other unrelated deaths and confirmed with the Baltimore City Police Department that those allegations were inaccurate because the deaths were ruled accidental. This claim, in conjunction with the aforementioned claim about his paid informant relationship, establishes that Richard Schaefer was willing to do and say anything in order to receive lenient treatment in exchange for his testimony, and that's exactly what he did in this case. Now, the state will argue that that particular claim has been unexhausted, but it was mentioned for the first time at the second round of PCR hearings before a court that had refused to reopen the Brady claims, and then it was raised in Mr. Horner's application for leave to appeal at JA 727, and Mr. Horner asked the Court of Special Appeals to reopen those Brady claims, thus sufficing to exhaust that claim. But it's not just that there's evidence that fundamentally undermines one of the state's key witnesses. Indeed, as the district court recognized, there are Brady claims undermining the testimony of the state's other key witness in the case, Miss Lorraine Smith, particularly that she informed the prosecution that she had no independent recollection of the events of the shooting, and that she was provided information about the alleged shooting by the state in advance of her testimony. Now, as to Miss Smith, the state accuses Mr. Horner of asking this court to reweigh an evidentiary contest fought before the state court. But in Gray versus Zook and Moore versus Hardy, this court drew a distinction between ignorance of evidence in the record and simply misweighing evidence in the record. And it's in the former category in which the state court's determination applies. Here, the state PCR court ignored critical evidence establishing the veracity of Miss Smith's recantation of her trial testimony, particularly an email 3 days before Ms. Smith signed her recantation, in which she affirmed all of the statements that would then become the basis for her January 9th recantation. Ms. Smith testified before the second post-conviction court at JA 1880 through 1887 that the statements in the recantation were consistent with her pre-existing email, that she sent the email of her own volition, and that the email provided the source for the January 9th recantation. Instead, the state PCR court, as the district court concluded, conspicuously omitted any reference of that January 6th email, and instead block quoted an email from the date before in which she said she didn't think that Mr. Horner deserved a new trial. The state court's explanation of the facts and decision to discredit Ms. Smith's recantation based on the fact that she was pressured to execute that recantation was objectively unreasonable in not grappling with that January 6th email. But that's not all that the state PCR court in the second round of post-convictions ignored on this record. Indeed, as the district court recognized, the state court did not assess Ms. Smith's testimony that she had no concerns about pressure from Mr. Horner's counsel at JA 1910 through 19112, or Ms. Smith's testimony that her execution of the recantation on January 9th was completely voluntary at JA 1850 through 54, or Detective Alex's testimony that he provided Ms. Smith with information about the shooting through forced answer questions at JA 2143 through 2162. Instead, the state court chose to rely on a May affidavit, but that May affidavit by Ms. Smith was significantly undermined by her testimony at the post-conviction hearing, all of which the state PCR court did not even grapple with. Indeed, Ms. Smith testified that she could not recall who wrote the affidavit, who gave the affidavit to her, how she got it, and she could not recall it in general, all of which is available to this court at JA 1890 through 91. In short, the distinction is between ignoring critical evidence in the state court record and simply reweighing that evidence. Here, the district court rightly determined that the state court reached an unreasonable determination of fact as to the Brady claims against Ms. Smith because it ignored critical evidence, not simply that it misweighed that evidence. Now, the state has attempted to cast this claim against Ms. Smith as about nothing more than the January 6th email and argued that that email was inadmissible. Now, as pointed out, it's about much more than just the January 6th email that the state PCR court ignored. However, it's worth pointing out that the January 6th email was read into the record before the state PCR court and used to impeach the later May affidavit, to bolster the credibility of the January 9th recantation, and to combat the claim that the January 9th recantation was provided under duress, and therefore was properly before the second state PCR court to consider. The court simply declined to consider that piece of evidence. On a final note, it's not as though the January 6th email was simply mentioned in passing in a moment of cross-examination. Petitioner's counsel, in closing for the second state PCR court, emphasized that email at JA 2241, and the second sentence of counsel for Mr. Horner's rebuttal for the state PCR court at JA 2257 was this, quote, Ms. Smith's email of January 6th is the controlling communication here. it was an unreasonable determination of fact for the state court to ignore this critical evidence that it had before it. And as a result, it reached an unreasonable conclusion as to these Brady claims. In sum, the district court rightly concluded that the state failed to disclose 6 different pieces of exculpatory evidence related to its only 2 key witnesses in this case. And therefore, this court should affirm. But that's not the only reason that this court can affirm the district court's judgment. Indeed, in this case, the district court rightly recognized that the state court record does not establish a knowing, voluntary, and intelligent waiver of Mr. Horner's right to a jury trial. As to this claim, it's important to remember that a function that where the courts come out is often a function of where they go in. And Supreme Court precedent and Zerks and otherwise makes clear that courts must indulge every presumption against the waiver of constitutional rights. And so,
Mr. Naples, this Judge King, if we were to agree with you on the waiver of the right to a jury trial point, wouldn't that render the arguments that you make about Brady and all that kind of moot here?
yes, Your Honor, this court can.
I mean, and agree that if he didn't make a proper waiver, then the whole trial falls away. You'd have to start all over, wouldn't you?
That's correct, Your Honor. Either claim standing alone.
So I don't understand. It seems to me like you got things kind of backwards when you argued about the Brady stuff, but that's all about the trial. Now you were arguing that he shouldn't even have, the trial's flawed completely, and because he didn't make a proper waiver, and that's what I'm getting at. If you're right there, we don't have to decide these Brady questions at all, and neither did the district court.
That's correct. That's correct, Your Honor. And the trial was problematic from the outset due to the inadequate waiver of the right to a jury trial. And so it's true that the Brady claims fall away if this court finds that there's an inadequate waiver to a jury trial. And
but the state says that the under AEDPA that the state court got it figured out well enough that that waivers got to be sustained. That's what you got to get around. Seems to me is whether AEDPA blocks you out.
here's where the state misapplies AEDPA deference in this case. The Court of Special Appeals cannot unreasonably apply clearly established Supreme Court precedent. And Supreme Court precedent dictates that courts must indulge every reasonable presumption against the waiver of a constitutional right, and that jury trial waivers must be knowing, voluntary, and intelligent. Based on this record, the only way that the Court of Special Appeals could have concluded that the waiver was knowing, voluntary, and intelligent was to misapply the burden of proof in the first instance. And indeed, if this court looks to the decision of the Court of Special Appeals, it is riddled with charges that Mr. Horner did not sufficiently speak up and object when his counsel attempted to waive the right to a jury trial for him, or did not seek clarification of the right to the jury trial. But the Supreme Court has clearly placed the burden on the state in the first instance to ensure that that right is protected. And in this instance, that right was not sufficiently protected on the basis of no more than a 5-sentence colloquy, which made no examination of Mr. Horner's background and circumstances, no examination of the charges or the potential sentence, no examination of the particular waiver of the right to a jury trial, simply acquiesced in his counsel's waiver. For the-
Counsel, this is excuse me, this is Judge Quattlebaum. As you go through and list the things that weren't done, isn't that pretty close to, as a practical matter, imposing Rule 11 requirement as a matter of constitutional law?
Your Honor, I see that I'm out of time. May I respond?
You answer all the questions. Don't you worry about the time. If you get a question from one of the judges, you answer it the best you can.
Thank you, Your Honor. Judge Quattlebaum, there are certainly no magic words that a trial court must say in order to ensure the waiver of a right to a jury trial. And there was no attempt here by the district court or by Mr. Horner to impose Rule 11-like strictures upon the state trial court. But it must be knowing, voluntary, and intelligent, and the state must satisfy the burden in the first instance. And it's incumbent upon the federal courts to look to the record and assess whether the record suffices to show a knowing, voluntary, and intelligent waiver. And this record does not meet that burden.
Anything further, Judge Quattlebaum?
No, thank you, counsel.
Judge Traxler?
No questions.
Thank you, Mr. Naples. We appreciate it. Appreciate your work in this case. Thanks
you.
for being with us. Mr. Jawar,
Yes, thank you, Your Honor.
you have reserved some time. Yes, sir. Go ahead.
Yes, I reserved 5 minutes. With respect to the jury trial waiver, my colleague misunderstands the assignment of burdens between direct appeal and collateral review. Because an on-the-record colloquy is not even required as a matter of constitutional law, only a valid waiver, the defects in the supposed litany, which isn't constitutionally required, don't go the distance to show on collateral review that he did not waive. He had a burden on collateral review to establish that he did do so, and there is no record from Mr. Horner objecting to what he said on the record, which is that he agreed with his attorney's advice and counsel's representation that they had discussed the matter. I agree with that, Your Honor.
That's been called the ZERPS waiver standard. As a matter of fact, I think that Justice Scalia referred to it, and it acknowledged that it's something, and how it's applied, they're familiar to the courts. So
That's right, Your
ZERPS,
Honor.
which was 1938, we're going back quite a ways here. A patent was in 1930, and then they came along with the waiver standard in 1938. Who wrote that ZERPS case? You remember?
I honestly don't recall, Your Honor.
Sutherland wrote the one about patent, I think. Justice Sutherland.
Justice Black wrote ZERPS.
Justice Black. Justice Black. Thank you, Judge Traxler. So you go right ahead. I just want to get you to acknowledge that we're talking about the waiver standard. We're talking about ZERPS rather than patent. Go ahead.
Right. Under ZERPS, we certainly have enough information in this record. ZERPS is a general standard, so the courts have wide berth in applying the particulars. Here, we have to remember that the trial court said that you have a right to a jury trial, that there would be 12 people chosen at random from the community, that he
didn't say you have a right to a jury trial. He didn't say that. He said you understand what a jury is. He talked about a jury. He didn't talk about a jury trial.
Your Honor, at JA 6...
The Maryland court talked about a jury trial. They said that meant he was talking about a jury trial, but I don't think the words jury trial are there for you. Go ahead.
I'm referring to the colloquy, Your Honor, and the court said you have the right to a jury trial at 1638 of the joint appendix. Not only that he had the right, but that they would be chosen at random from the community. He'd have the right to participate in the selection of those jurors, and that any verdict would have to be unanimous, and that they would have to find beyond a reasonable doubt and to a moral certainty that he was guilty. So we believe that as to the sufficiency of the colloquy, it certainly is enough to establish the knowingness, and that the CSA, the Court of Special Appeals, was not objectively unreasonable for finding that that was enough. If I may address some of my colleagues' points about the Brady issues, I want to make perfectly clear that under Kyle's, which my colleague spent a good 5 to 6 minutes talking about, the only fact of which the defense ever claimed it was unaware, was the fact that he had been occasionally paid, Mr. Schaefer, for some of his undercover work. The relationship, the 10-year relationship, defense counsel admitted at the 2010 UPPA hearing, he was fully apprised of that. So some of my counsel's rhetoric, which seems to waffle between the 10-year relationship and the separate issue of whether he was in fact paid, is meant to augment and sort of cover over some of the materiality problems with their claim. With respect to unrelated deaths, I want to point out that the state actually disclosed that, as we've argued in our brief, in their supplemental disclosures. The UPPA court found that as a matter of fact. And as to Ms. Smith, I really don't have the time to regale the court with our very distinct understanding of the record, but I think what you heard demonstrates in and of itself that this was an evidentiary contest, and there was evidence on both sides. Under 2254 D2, to be objectively unreasonable, a fact finding has to lack evidentiary support to a degree beyond the clearly erroneous standard, which applies on direct appeal. The Second Circuit has said that that means that the UPPA court must have misstated or misapprehended the record. There's no allegation of that. The UPPA court simply chose different emphases and found different aspects of the record appealing and credible to it.
Counsel, this is Judge Quattlebaum. Returning back to the Schaefer issue, I want to make sure I understand what you just said in response to your colleague's argument. He referred to certain testimony, I think from the second PCR hearing, that he said we aren't, that doesn't fall under the EDPA deference standard. Is it your testimony, or not testimony, sorry about that, is it your position that what he said, I think you were just saying what he said didn't relate to the paid issue, or were you responding to that in some other way?
Well, there's two different points to be made there. One is that with respect to Schaefer's relationship with Detective Hahn, that was fully understood and known by the defense. The only thing that's been litigated in this case was the fact that what the defense did not know was that he was occasionally paid. My counsel, my colleague here sort of paints with a broad brush and referring to the relationship as a whole. I want to make sure the court understands that the relationship was fully disclosed and cross-examined. In fact, the trial court made mention of that in its verdict. Now, the other point that my colleague made was that the court now should consider that Detective Alex had direct knowledge because he testified to that. I don't want to belabor the point, but in our reply brief, page 20, we addressed this. This is a whole section of our brief. This argument that Detective Alex had direct knowledge is based upon the cross-examination that was done in 2018. And that's not before this court. It wasn't even argued to the district court. This is trotted out for the first time before you. This is not new evidence that escapes EDPA review. It is completely procedurally defaulted because it could have been argued in the 2010 hearing when this issue was fully ventilated, but they didn't call Detective Alex. They only relied on Detective Hahn. And if you read Detective Alex's testimony in 2018, he's actually not speaking from the perspective of trial. He's speaking from his perspective in 2018, meaning he didn't know himself in the time of trial that that even there was a relationship at that time. The Detective Alex did not know, much less that he was being paid. So that section of our brief should adequately respond to that. That's not an opportunity to avoid EDPA. It's actually an affirmative problem. And for those reasons, we would ask the court to reverse the judgment below.
Judge King, I have one more question. I have one more. I apologize, Judge King.
Go ahead, Judge Quattlebaum. Go right ahead.
So,
still there, Mr. Grawar?
Yes.
So my question relates to an issue that you, I think, raised about, piecemeal litigation. And I understand that point, I understand your argument, I think. What are you asking us to do with respect to that issue? And obviously the district court didn't address the Strickland claim, and you requested that be done below. Are you suggesting that we do anything about that issue at this stage?
What I would ask, Your Honor, is for an opinion that, as a matter of the court's supervision of the district court, its inherent authority to supervise the proceedings, that you adopt the policy of the Clisby decision and jurisprudentially prevent this in future cases. At this point, I don't know that the court can really economize the case. It seems to me that we're going to be facing these Strickland claims in a future proceeding should the state prevail here. But either way, it prolongs the litigation in ways that contravene everybody's interests. It contravenes the victim's interest against unreasonable delay, which is a right under the Victims' Rights Act. It certainly contravenes the state's interest in the expeditious resolution of these cases and to limit federal interference with its judgments and its correctional programs. And it even hurts the petitioner because, as you know, the pendency of a federal habeas petition doesn't toll the statute of limitations. So you might expose those claims should the court do this again to a previously unavailable affirmative defense, could also face a successiveness problem. So this type of saving claims for later is antithetical certainly to the spirit of the final judgment rule. And we would ask that you jurisprudentially recommend against it so that district courts don't do this in the future.
Thank you.
You don't like the way they did it here.
I'm sorry, Your Honor?
You don't like the way they did holding some issues back?
That's right.
What about the question that I asked your colleague there, Mr. Naples, about if the plea or the waiver is defective, why we wouldn't stop right there, would not address these Brady issues or anything else? You disagree with that too?
No, I don't disagree with you, Your Honor. And an affirmance on any one of the grounds found by the district court could potentially obviate the rest.
Okay. Thank you, sir.
Thank you, Your Honors.
Appreciate the arguments of counsel. Your case will be taken under advisement. Madam Clerk, now do we take a break or we go on to the next case?
That's up to you. We can. Ms. Tarleton?
Thank you. Good afternoon, and may it please the court. Jackie Tarleton for Dawn Bennett. Your Honors, the district court's denial of a 60-day continuance violated due process in a case with 15 terabytes of discovery, alleging a $14 million loss, with sentencing exposure up to Ms. Bennett's natural life, where the government presented 32 trial witnesses and previously acknowledged the complexity of the case, as did the district court, which is best described at pages 4 through 6 of our reply brief. The government agreed this case was extraordinarily complex. In December 2017, it pushed for a trial date after September of 2018, more than 9 months away, citing the duration of the scheme, the length of the investigation, the nature of the charges, and the sheer volume of victims and loss amount. It characterized this as a complex case with substantially more voluminous discovery than a typical case. And the district court agreed. It said that this case was far more complex than your average case, with 17 counts, 2 co-defendants, ongoing discovery production, and terabytes of electronic discovery. In fact, in January of 2018, the government said that 5 months to trial was not enough for any lawyer with white collar experience to get up to speed. It would, quote, be difficult, if not impossible, for an attorney for the government to get up to speed even by June. And that's at the Supplemental Joint Appendix, page 103. To understand the nature of the discovery in this case, I think it's important to understand both volume and nature. First, with respect to volume, 15 terabytes represent 6.5 million pages, or 1,300 filing cabinets. With the 35 days available to Mr. Boyle, that's reviewing 37 filing cabinets, or 185,000 pages a day.
How many lawyers when time Mr. Boyle got in, how many lawyers had been involved in representation or had represented?
I'm glad you asked that, Your Honor.
You're now client, yeah.
Because I think the government's characterization isn't quite right. In the first month after the complaint was filed, there were 2 lawyers who entered sort of limited appearances. Stephen Greminger never actually entered an appearance, but believed he was going to appear as local counsel. Mark Shamel entered a conditional limited appearance, but was only in the case for a couple of weeks. Within 1 month of the complaint being filed, the Federal Public Defender's Office was appointed, and they were in the case for 4 months. And in February,
Is that the Federal Public Defender's Office in Maryland?
That's correct, Your Honor. Yes.
Right,
and then
go ahead. All right, that's the third one. Then go ahead.
Well, I believe though that it's the first that was. I understand
you don't want to count the first 2, but I'll count the first 2. Go ahead.
Understood, Your Honor. And then in February of 2018. There was a law firm that entered an appearance that ultimately withdrew for a conflict of interest. In fact, Judge Zinnes encouraged one of the lawyers from that firm to take the 5th in a proceeding before her. So they were removed in May of 2018, not through any fault of Ms. Bennett. FPD was reappointed. They were in the case for 3 months before Dennis Boyle, the lawyer who ultimately took this case to trial, was appointed on August 28th of 2018. I think this duration is really important to note. That's exactly 1 year from the date the criminal complaint was filed. And I was interested, so I looked it up. The median time from filing to disposition of criminal felony cases, including pleas in Maryland, is over a year. So despite this case being complex.
Now are you and your office the only lawyers since Mr. Boyle?
She did have another lawyer for sentencing, Your Honor, but that was after. Okay. After the issues that we've raised as part of our due process claim.
And you're with the Public Defender's Office in North Carolina?
I am, that's right.
So it depends on how you count. There's between 5 and 8 lawyers or sets of lawyers, correct?
All told, I would say there were 7 entities that entered an appearance over the entire course of the case, and that includes the appeal.
Very good.
Counsel, this is Judge Quattlebaum. I think I'm right on this, but tell me if I'm not. In August 30th of 18, Boyle, I think he had appeared 2 days before, and in that hearing said that he was aware of the discovery and could be prepared. I think I read that right. And then I know there was a later emergency motion for a continuance in, I think, September 12th. But I think the basis of that emergency motion, which I think is the motion that's on appeal, tell me if I'm wrong about that, the basis for that was Ms. Bennett's medical issues rather than discovery issues. Do I have that right?
So both of those are correct, Your Honor, but I'd like to offer a little more clarification if I could. First, with respect to Mr. Boyle's statement, he did, after the continuance had been denied by the judge, say that the question was more a question of identifying witnesses and locating them. He said, we'll work on that expeditiously. But there were issues with the experts that he contacted, and those experts cited the lack of adequate preparation time as reason why they could not provide expert opinions that were satisfactory either to the government or to the district court. And we detail this at pages 10, 11, and 12 of our opening brief, where the government criticized one of the experts, Macy, for giving, quote, no explanation of the source of his understanding and saying he didn't appear to have ever reviewed certain documents. Van Zant at voir dire hearing, where he offered his proposed expert testimony, the government said it wasn't based on sufficient facts or data, was concerned that Mr. Van Zant hadn't reviewed certain documents in the case. And Mr. Van Zant said he didn't have the opinions that everyone was looking for because the defense didn't have enough financials for him to give a value. And part of the reason his report isn't more precise is simply timing. And this is at JA 1343 and 1346. So I think it's clear from the record we have before us that the experts didn't have adequate time to prepare a sufficient opinion. Mr. Boyle didn't have adequate time to investigate potentially exculpatory witnesses or to develop fulsome cross-examinations of the witnesses who did testify. And that's borne out by the fact that the one witness he did proffer at a voir dire was excluded by the district court because of inadequacies in his proffered testimony. The other two he ultimately did not call, but one of the reports was criticized by the government for being insufficient. And in fact, the defense only called one witness once the case did go to trial. And again, this was not an extraordinary continuance that Mr. Boyle asked for. He asked simply for an additional 2 months to get up to speed. The government had already said that 5 months wasn't enough for a new lawyer to be prepared. And Mr. Boyle filed his motion to continue the next day after he was appointed. And he reiterated his concerns about being prepared for trial in his filings related to experts. This court has at least three times vacated convictions because of a failure to grant a continuance. That was in United States against Evans, Shirley versus North Carolina, and United States versus Walker. And it refused to give preclusive effect where it believed that insufficient time was given for a lawyer to be prepared, and that was in Lee versus Winston. There's been an allegation that Ms. Bennett was somehow acting in a dilatory fashion by asking for this continuance, but I want to make sure the court understands that Ms. Bennett was in pretrial detention at the time that this motion was filed, and she had no incentive to delay the trial outside of an interest in making sure that her counsel of choice was adequately prepared. And as the government notes in its response, she had previously sought the earliest possible trial date, but was willing to agree to more than 60 days of a continuance in order to accommodate the court's schedule and the government's schedule.
But the bottom line is on this issue is that it's reviewed on appeal for abuse of discretion.
That's correct, Your Honor. But as I've noted, this court has previously found that that discretion has been abused, and where the average.
Well, we can find discretion abused, but that's the standard of review.
It is, and we absolutely agree with that. But I think where the median time from filing to disposition in criminal felony cases is just over a year, and this case, in fact, went to trial in that amount of time, despite how very complex everyone acknowledged it was. I don't think that any lawyer could have been prepared by reviewing 15 terabytes of discovery that include financial documents that required an expert's searching eye and professional opinion to fully understand. I don't think that any lawyer could have been adequately prepared, consistent with Ms. Bennett's due process rights. So we would ask the court to vacate her conviction for that reason. We'd like to also discuss a little bit today our argument about the district court's 20-year sentence, which we believe is procedurally and substantively unreasonable. I'd like to focus on the procedural aspect today, unless the court has other questions. But the district court here treated the advisory guideline range as presumptively reasonable. It said it was doing so 3 times. Those are at JA 2103 and JA 2118 of the joint appendix. The judge said, I start with the guidelines. They are presumptively reasonable.
I'm sorry, counsel, if I could, Ms. Tarleton, if I could interrupt, this is Judge Quattlebaum, and I'm glad you brought that up. You're correct about the 3 references to presuming reasonableness based on the guidelines. How do you respond to the fact that the district court went through the 3553 factors, in fairly good detail, and sentenced Ms. Bennett to not just below the guidelines, but below the government's requested sentence. And as you answer that, consider Mendoza's holding that we look beyond the words to what the district court did. So, words, you're right, but what about what the court did?
Absolutely, Your Honor. And I think Mendoza is a great place to start, because if you look at what actually happened in Mendoza and not just what the court said, the court actually did vacate and remand that case for resentencing, despite the fact that the court discussed certain 3553A factors. And the same is true in the Nelson case, where the Fourth Circuit had previously affirmed a district court sentence, and the Supreme Court said, no. Even though the district court did not treat the guidelines as mandatory, it nonetheless improperly erected a barrier. It shifted the burden by treating the guideline range as presumptively reasonable, which a district court is not entitled to do. We know from this court's previous cases, including United States versus Torres Aguirre, and that's at 481 Federal Appendix 803, that even a downward variant sentence, if it suffers a procedural error, should be vacated and remanded. So the fact that it was a below guideline sentence that was ultimately imposed is not dispositive in this case. We also cite to the Wilms and Peguero cases in the Sixth and Second Circuits, where below guideline sentences were vacated and remanded, where the district court treated the advisory guideline sentence as presumptively reasonable. And that's important.
How did the district court treat it as, besides using the words, which I recognize may be a problem, how did the district court treat the guidelines as presumptively reasonable?
I think we can look, Your Honor, at the sentence the district court ultimately imposed, because even though it was a below guideline sentence, it was still a 20-year sentence. Ms. Bennett had requested a 3-year sentence. So where the district court ended up is significantly closer to the advisory guideline range and to the sentence requested by the government than it is to the sentence requested by Ms. Bennett. And I think that is further evidence, in addition to the court's statements on the record, which again were 3 times, it wasn't an offhanded one-time remark, that she was treating the guidelines as presumptively reasonable. And in fact, she said, according to the guidelines are presumptively reasonable according to the law in the Supreme Court and the Fourth Circuit, which to me suggests a feeling of being bound by what she believed the precedent to be. And of course, under Nelson and Mendoza and Rita, that would be reversible error for this court. And we believe that Ms. Bennett's 20-year sentence should be vacated and remanded for that reason. I would also note just briefly in Mendoza, this court said that it would only not remand if there were, quote, no serious possibility that the district court treated the guidelines as presumptively binding. And I don't think, given both the district court's statements on the record and the sentence that she ultimately arrived at, that can be fairly said from this record, including the fact that the government never argued harmless error in this case. I would like briefly...
Excuse me, this is Ms. Tarleton, this is Judge Schraxler. Do you agree that we apply plain error analysis to this problem?
To the question of whether the guidelines were treated as presumptively reasonable?
Yes.
No, Your Honor, I don't. I believe that by requesting a sentence below the sentence that she ultimately received, Ms. Bennett preserved her right to argue that the sentence was procedurally unreasonable. And so I believe that this should be reviewed for abuse of discretion.
Okay, thank you.
Thank you. And just briefly, Your Honor, I also want to mention our forfeiture argument. We believe that the $14 million forfeiture order was excessive. And given my limited time, I just want to focus briefly on our first statutory argument, which is that neither 18 U.S.C. 371 nor 15 U.S.C. 78 JB is specifically enumerated as a basis authorizing criminal forfeiture in any of the criminal forfeiture statutes. And the closest description is a, quote, offense involving fraud in the sale of securities, and that's in 1961. But here we know...
I thought conspiracy was in there.
Conspiracy is in there, Your Honor, but the conspiracy referenced in Ms. Bennett's superseding indictment is a conspiracy, a general conspiracy under 371 pegged to 15 USC 78 JB. And we know from
That's 371 references every criminal offense in the United States Code.
But her indictment, Your Honor,
it's a conspiracy to commit an offense against the United States.
That's correct.
Right.
And the offense that is enumerated by the government in the superseding indictment is 15 USC 78 JB. It's not securities fraud. It's 15 USC 78 JB. And that offense, we know from the Supreme Court's decision in United States versus O'Hagan, does not necessarily involve fraud. And because of that, we don't believe that it can fairly be considered an offense involving fraud in the sale of securities, and therefore does not authorize the criminal forfeiture that was ordered in this case. So for these reasons and the reasons in our briefs, we would ask the district court to vacate Ms. Bennett's convictions and remand for a new trial, or at least a new sentencing hearing.
So I have one more question on the forfeiture issue, Judge King, if I could ask that.
You go right ahead, Judge Quattlebaum. Go right ahead.
Thank you. Counsel, does a little bit of our problem is a lot of the arguments about the forfeiture, finally show up in the reply, so we don't really have the government's position. I guess we'll hear that in a little bit. But taking everything you say is true in your reply about Section 78 being looked at under the categorical approach, doesn't the wire fraud conviction also provide a basis for forfeiture under the RICO statute? And while you rightly point out that in the actual counts, I guess 6 through 17, those don't total up to the 14 million. They do have the forfeiture claim that specifically references the 14 million. So why wouldn't the wire fraud be an independent basis for forfeiture, even if we, agree with you on everything else?
Judge Quattlebaum, thank you for that question. We are only challenging the forfeiture that is pegged to counts 1 through 5. And so for the amount that, and I believe probably given the posture of the case, it would make sense for the district court to address this in the first instance to get the precise monetary values. But we believe that the 6 through 17, we are not challenging that forfeiture amount under this first statutory argument. So we're not contending that wire fraud doesn't authorize criminal forfeiture. But we just believe that the amounts attributable to counts 1 through 5, which is a significant portion of the $14 million forfeiture judgment, was not authorized by statute.
Okay, all right. Last question on that. The argument about application of the categorical approach to 78 to see whether it involves sale of securities or something broader than that. I understand your application of the general categorical approach cases, but there's not a case that actually addresses that question in the context of this statute, is there?
Not that I'm aware of, Your Honor, but I think Shular discusses, an offense involving fraud. I think we get sort of where we need to go, the fact that it should be an elements match. So that would be the closest case that I would point you to.
What case? Could you say that again, please?
Shular, the recent Supreme Court case, I believe it came out in maybe June.
Okay, thank you.
Thank you, Your Honor.
Thank you very much, Ms. Carlton. You saved the rebuttal time as well. Now, the government is represented by Ms. Wine, I'm sorry.
Yes.
You there, Ms. Wine?
I am. Good afternoon. May it please the
Good to have you
court.
with us.
Thank you. Good to be here. May it please the court, Jennifer Wine on behalf of the United States of America. I'd like to jump in on this last issue and the questions that Judge Quattlebaum had asked about the forfeiture argument. As correctly pointed out, the argument seems to have evolved, and the current argument of the defendant was not raised until the reply brief. Therefore, the government has not had an opportunity to cite authorities in its brief on this issue, but I'm happy to address it here today. And if you would like authorities in support of the government's argument, I'd be happy to submit supplemental briefing on that point. I think it's an easy argument to dismiss with. As Judge King rightfully pointed out, the appropriate forfeiture statute in this case, which is 981A1C, as incorporated into this criminal case by Title 28, Section 2461C, it explicitly includes a conspiracy to commit any of the enumerated offenses that are listed in 981A1C. And one of those enumerated offenses includes wire fraud, and thus a conspiracy to commit wire fraud as charged in the superseding indictment, as well as the securities fraud conspiracy that was charged in count 1. So my argument being that we don't even need to reach this argument that is raised for the first time on the reply brief by the defendant, that somehow the language fraud in the sale of securities punishable under any law of the United States under Section 1961, somehow it should be read to mean fraud in the sale of securities punishable under any law of the United States, except for Title 15 securities fraud. We don't even have to reach that, because here this defendant was also convicted of a wire fraud conspiracy. And forfeiture is provided explicitly under 981A1C and 28 U.S.C. 2461C for the proceeds of that wire fraud conspiracy. It's also clear that the proceeds of that wire fraud conspiracy are also the $14.3 million that the defendant received as the proceeds that she obtained from her victims in this case. Just by looking at the superseding indictment in this case, it incorporates into the wire fraud conspiracy count, it incorporates the same manner and means as the securities fraud conspiracy. And it basically references in the manner and means that the defendant and her co-defendant obtained at least $20 million, I believe it was from 46 individual victims in this case. And I believe that is at Joint Appendix, it is at, one second. It's at Joint Appendix 61, and that is paragraph 21T of the superseding indictment, which says between in or about December 2014 and in or about July 2017, Bennett and Mashko solicited and received over $20 million from more than 40 different DJ Bennett investors. The testimony from trial and the evidence admitted at trial that supported the government's $14.3 million forfeiture money judgment was the testimony of a forensic accountant from the FBI. And the forensic accountant relied upon an exhibit, which was government's exhibit chart 6D. And her testimony, which can be found, one moment. Her testimony on that point basically says that the $20 million figure, less approximately $6 million that were paid back to victims, were the proceeds or the ill-gotten gains that Ms. Bennett obtained. That's the same whether we're looking at the securities fraud conspiracy or whether we're looking at the wire fraud conspiracy. So this is really an argument that we don't have to have. That said, we can still discuss the fact that securities fraud, I do believe, is included as specified unlawful activity, which is picked up in Section 981A1C. 981A1C references specified unlawful activity under Section 1956C7, and 1956C7, in turn, if we follow the trail, references Section 1961. That is the RICO predicate statute. And in the RICO predicates, we have fraud in the sale of securities punishable under any title of the United States. And there is nothing here, there are no cases cited in the defendant's reply brief standing for the proposition that that language should be read not in its plain meaning, but instead read to exclude a Title 15 offense specifically Section 10B of the Securities and Exchange Act. So it's just not, it strains any reading of that statute to say that it does not include that. But again, to get back to the argument, I don't think we have to get there. To the question of whether there is any case on point on this, I do believe it is one of the cases that was cited in the defendant's reply brief. With apologies for my pronunciation, I believe that it's Nijuan v. Holder is the case. And in that case, the Supreme Court refused to apply the categorical approach to a different provision. This was the aggravated felony provision of the INA, which specifically referenced fraud language. And I want to get it right here on specifically what it said. It referenced both fraud and deceit. And the statute said, an offense that involves fraud or deceit in which the loss to the victims exceeds $10,000. And in Nijuan, the case that is cited in the defendant's reply brief, the court specifically held that that language, which is very similar to the fraud in the sale of securities language found in the RICO predicate offense, required looking to the circumstances of the offense. And so I would disagree, to the extent that this argument is properly before the court today, I would disagree that the categorical approach would have to be applied to the RICO predicate and whether or not the Title 15 offenses of which this defendant was convicted of should be, that the categorical approach would have to apply to those. I don't believe that the case law supports that, even the case law cited by the defendant. I don't Hagen as changing that in any way, the case that was cited by the defendant. And moreover, in conclusion on this point, the wire fraud conspiracy, as Judge Quattlebaum points out, it has the same proceeds. And so the $14.3 million in proceeds is supported by that. So having used most of my time to address that. Yes.
Counsel, I'm sorry, I'll be real quick because I know you got other issues. Isn't your position is that we look at this whole forfeiture question under plain error review, correct?
Yes, Your Honor, and that's because this was not raised below. And while the defendant raises that the fact that the forfeiture judgment was challenged at all below preserved this issue for appeal and therefore a de novo review should apply, that is inconsistent with the holdings of this court, which in Massenburg, the court held that an objection on one ground does not preserve an objection on a different ground. And then later in Lavabit, the court held that if a party wishes to preserve an argument for appeal, the party must press and not merely intimate the argument during the proceedings before the district court. None of the three, or if you consider it four with the new argument raised in the reply brief, none of these arguments were raised below. While there were some challenges to the forfeiture, if you look at the transcripts of those hearings, they are not the arguments that are raised here. They are not the constitutional challenges, et cetera. So we do believe that plain error is the appropriate standard of review, and we don't believe that there was any error here, let alone plain error in the district court's order of the $14.3 million forfeiture money judgment. If
Ms.
there are
Wine,
no,
this is Judge Traxler.
Yes.
I have a question before you leave the forfeiture issue. Is there a practical reason for why you want this amount forfeited in addition to requiring it as restitution?
Yes, Your Honor. There is a practical reason as well as a legal reason. I'll address the practical reason first. As the defendant
That's only what
notes
I'm interested in.
I will stick to that then. As the defendant notes here, there were not a good number or not a good deal of liquid assets remaining. So the proceeds or the ill-gotten gains of these offenses had been spent by the defendant before they could be seized. And so at the time that we arrived at sentencing in this case, there was very little in liquid assets remaining to compensate victims in this case. And as I said, there were more than 40 of them owed more than $14 million. As this court has recognized in its Blackmun decision, which I think has a good discussion of the legal bases between forfeiture and restitution, but also references the practical consideration. Where we ended up in this case was with a $14.3 million money judgment, as well as the forfeiture of substitute assets. That was the amendment that was made to the preliminary order of forfeiture, was to leave the forfeiture money judgment, and then in partial satisfaction of that money judgment, to forfeit a number of substitute assets of the defendant, which were primarily, personal property. In forfeiture, there is a well-established mechanism in a case like this through the U.S. Marshal Service with which to liquidate personal property or real property, which is not at issue in this case, to liquidate those, to get them into liquid assets or cash that can then be applied to restitution through a process that is known as restoration. There's a separate...
Okay, thank you. Thank you. You've answered my question.
Thank you, Your Honor. So if there are no further questions on forfeiture, I would like to turn back to address the questions that were raised as to the continuance. As Judge King appropriately pointed out here, there were a good number of lawyers prior to Mr. Boyle. Mr. Boyle was at least the fourth change of counsel, if you don't count the FPD or the federal public defender having been in the case twice. But I think we have to look at the continuance in light of the reasons that the judge here decided not to grant that continuance. And I think the most important context there is the timeline. So if we look at this, what we had the arraignment that was on the superseding indictment, and that took place in December. It was on December 5th of 2017. And that's at the Supplemental Joint Appendix 1. At that arraignment, the trial was tentatively set for September 4th of 2018, and that is SJA 119. On December 19th of 2017, the government filed a motion to set a trial date. So we had a tentative trial date, and we moved to set in a trial date officially, and to exclude time under the Speedy Trial Act. And as defendant correctly noted, the government did request that the trial be set for after September 3rd, 2018. At the hearing on that, the defendant did ask for the earliest possible trial date, or July 2018, and the court set in the trial date for September 4th, 2018. Fast forward, the federal public defender comes into the case in May of 2018, and the court continues the trial until October 2nd, 2018, which was ultimately the date that the trial did begin. On August 8th, 2018, so that was before this second continuance that is discussed in the appeals, the defendant requested another continuance. And the district court denied that continuance, noting both accommodations that had been made by the court to make sure the defendant was prepared for trial, and that's at SJA 155 to 56, as well as the defendant's own conduct in thwarting her cooperation with her defense counsel at that time, who was the federal public defender, and the orderly progression of the case. After that denial, then 2 weeks later, Mr. Boyle enters the case. And on August 29th, 2018, Mr. Boyle files this second motion for the continuance that's at issue here today, seeking a 60-day continuance. As we noted, he was the fifth new counsel in 13 months between the defendant's initial appearance and trial, and he was retained approximately 6 weeks prior to trial, which I think distinguishes this case from many of this court's prior decisions considering continuances in which defense counsel was brought in only a matter of days before the trial began. But the district court...
He was retained counsel, was he not?
That's correct, Judge King. The district court gave several reasons on August 30th at the hearing on that motion on the continuance, and I think it's important to consider those reasons here in light of the Supreme Court's Unger decision, where they said that there are no mechanical tests for deciding when a denial of a continuance is so arbitrary as to violate due process. The answer must be found in the circumstances present in every case, particularly in the reasons presented to the trial judge at the time the request is denied. And so looking at those reasons here, we have three primary reasons that the court denied the continuance. The first is that Mr. Boyle confirmed at the outset of the hearing on the continuance, before the judge would even let the federal public defender withdraw from representing the defendant, she confirmed that Mr. Boyle would be able to try the case on the date that was scheduled on October 2nd of 2018. She acknowledged that he had entered his appearance and accepted the retainer knowing that the trial was set to begin in 6 weeks and that he wouldn't have done so if he had not intended to be prepared. And that's at JA 103 and 107. And then he repeatedly confirmed that he would be able to proceed and try the case on the date that it was scheduled. And that's at JA 102. And that discovery would not be a problem is at 116 to 117. The judge specifically noted the size of the firm, which was 170 attorneys approximately, as set forth in the government's motion, or opposition, which was JA 99, and that with a firm of that size, they would be able to blow through discovery, particularly in light of modern technology. I don't think that it is appropriate to consider the number of file cabinets, because we now have technology that allows counsel to blow through discovery much faster than a page-by-page review. He would have had 8 to 9 weeks, the judge recognized, before the defense case would even come up. And she noted that many of the witnesses had already been interviewed by prior counsel, that's at JA 113 to 114, and offered to assist Mr. Boyle in getting that work product if that became necessary. She specifically referenced that the defendant had her counsel of choice, which was a firm with enough resources and with able and competent assistance of the defendant would be ready to go to trial. So that was the first thing. The second was that out-of-state witnesses had already been subpoenaed by the government for the trial date. That included, as the court recognized, 10 out-of-state victim witnesses, and that's at JA 112, 5 of whom had health concerns or family members with health concerns, and that's at JA 113. And then finally looked to the court schedule and the parties' schedule. At that point, the judge referenced that there was no availability for a trial 60 days out, and that's at JA 113, and that a longer continuance would run into problems with a key law enforcement witness who was unavailable for 3 months from March to June, which would prejudice the government. She also reviewed counsel both for the government and for the defendant. There are other trial commitments which would prohibit certain other dates from being available to reschedule. And she referenced that the kind of block that we need to do this right from all counsel involved, and you are not, if not the 10th and close to the 10th defense attorney who has entered his appearance in this case, and that refers to each individual attorney referencing, that's why the number is different. The judge held, I simply cannot move this trial, and that's at JA 116. And then finally, including, she noted that to move it would basically allow the defendant, a defendant with resources, to find resources close in time to trial, and then have that counsel say, I can't be ready, or I can be ready, but I really wish to be ready later. And then the orderly administration of the case is upset. And that's simply not what the cases in this court have held. A defendant's right to counsel cannot be used to thwart the orderly administration of the court. So I think looking at the reasons that the trial judge relied upon here, it's clear that this denial of the continuance was not an abuse of discretion. It was well reasoned, and defense counsel made clear that he would be able to proceed. The final point on this that I'd like to make is that the issue that is raised with respect to the expert witnesses doesn't really tell the full story. The defendant herself elected not to call 2 of the proposed experts. That would be the corporate law expert and the economics consultant. And that's at JA 195, JA 1313, and JA 1214. And for the third proposed expert witness, Mr. Van Zant, the defendant herself elected to withdraw 2 of his opinions, and that's at JA 13 to 40. And the district court excluded testimony as to the corporate valuation of djbennett.com because it was not based on reliable data and methodology, and that's at JA 1464. So taken together, I think it's clear that the trial court did not abuse the discretion on this. With the remaining few seconds I have left, I would like to address the sentencing issue here. I do think that the reference to Mendoza is the correct one here. And I think that this is not a mere this is in fact a mere passing reference. If you look at what the judge actually did, instead of looking at the passing references out of context, it's clear that the judge here did not believe that the guidelines were presumptively reasonable or that she was bound by those, as evidenced best by the fact that she ultimately imposed a sentence that was 84 months below the guideline sentence. But instead here, she made those passing references while first explaining the fact that the government in this case had actually made a below guidelines recommendation. And then second, reference them before reviewing all of the reasons that they were not binding in this case. And with that, I ask that the court affirm the judgment below.
Judge King, this Judge Traxler, I have two questions, if you don't mind.
Yeah, you go right ahead. Ask all you want, Judge Traxler.
Thank you. Ms. Wine, first of all, with regard to the question of involving the district judge's statements that the guidelines were presumptively reasonable, do you agree with your opponent that the standard of review is harmless error?
I believe the standard of review on that, as set forth in our brief, is one of reasonableness, and that the courts look first to the procedural reasonableness and then to the substantive reasonableness. I don't agree that I don't agree necessarily that it's harmless error.
But the question is, which is the standard of review, presuming it was error? Is it harmless error or plain error analysis?
Your Honor, it's a good question. I'm taking a quick look back at our brief.
You know, your brief didn't address it. Your brief didn't even address whether or not it was presumptively unreasonable.
Well, I don't believe that this issue was raised below. And
it was raised on the brief, though.
Yeah, it has been raised on the brief, but I believe that because the issue was not challenged below, that I do believe that plain error would be the appropriate standard of review.
All right, and my next question is this: there were some statements by the district judge that even if she was wrong on her sentence, she would on her construction of the guidelines, that she would still give the same sentence. And we have authority that says in a situation like that, if there were errors in the giving of the sentence or in the computation of the guidelines, that error would be harmless. But do you rely on that theory at all? I didn't see that case cited in your brief.
No, Your Honor, I don't believe we do.
Okay, thank you.
Thank you.
That concludes my questions, Judge King.
Thank you, Judge Traxler. Thank you, Ms. Wine. Ms. Tarleton, you've saved 3 minutes.
Thank you, Your Honor. Perhaps I should start at where Ms. Wine left off with the sentencing argument. I would point to this court's decision in Mendoza, where in fact, the district court in that case, where again, there was a vacatur and remand of the sentence, the district judge there had said, viewing it as objectively as I possibly can, I cannot see a reason for a variance. So it's not as though the court in Mendoza, which was vacated and remanded, did not make a consideration of the 3553A factors. So I don't think that that's a reason for this court not to vacate and remand for resentencing, given the district court's multiple statements and where the district court ultimately ended up at sentencing. Under this court's decision in United States against Lynn, we believe that we've preserved this argument when Ms. Bennett argued for a sentence below the one that she ultimately received. So we do not believe that this is reviewed for plain error. And we appreciate the government's concession that it did not raise an issue of harmless error. With respect to forfeiture, I wanted to mention where this was raised at the district court. That's at JA 19.
The government says it's plain error review. You agree that you lose if it's plain error review?
Plain error review as to the sentencing?
Yeah.
We heartily disagree that it's plain error review, but I do think that the error is plain.
The government says it's plain error review. If it is plain error review, do you accept the proposition that you lose?
No, I don't, Your Honor, because I think under this court's cases in the Supreme Court's case in Rita and Nelson, this court's case in Mendoza.
So you say it's harmless error review?
I believe it's reviewed just for reasonableness, for abuse of discretion, procedural reasonableness, and then substantive reasonableness. And we believe that we preserved it.
Any error has to be prejudicial. If it's harmless, it doesn't happen.
Your Honor, I would point this court to its decision in Venable, where when the district court didn't raise a similar argument, it was not entitled to rely on it. And Ms. Wine did acknowledge that the government never raised the argument that this error was harmless. Not to mention the fact I don't think it's harmless in this case. Ms. Bennett received a sentence 17 years longer than the one that she asked for. And the district court 3 times on the record explained that she believed that the advisory guideline sentence of 27 years was presumptively reasonable. And under that,
Counsel, let
One
me.
of the judges has a question.
Yeah, I'm sorry. I just want to follow up. I mean, you're right that the issue of harmlessness or plain error wasn't raised by the government, but the standard of review. Is that something that can, if they don't raise, can be abandoned in any way or waived? Isn't the standard of review? That's a legal principle. I mean, what's the effect of the government not arguing for plain error review in their brief?
I would send this court to its decision in Venable, and I think that they have given up the right to argue that. And I also don't think it's harmless in this case. I think that. Yeah.
Okay. Thank you.
Thank you, Your Honor. With respect, briefly, if I might, to forfeiture, this is preserved at Joint Appendix 1937, where Mr. Zaff says, "We do believe that under the forfeiture statute, the court's power is limited to the statutory authority for forfeiture, not necessarily for proving the substantive counts. If the amount is not enumerated in the indictment, then it should not be forfeited as part of the money judgment." So we believe that our statutory argument was squarely presented to the district court. I see that I'm out of time, so unless there are other questions, we would ask the district court to vacate the district court's judgment and remand either for a new trial or at least for resentencing.
Judge Quattlebaum, Judge Straxley, further questions?
No questions.
No questions from me either.
Thank you very much, Ms. Tarleton.
Thank you, Your Honor.
That would take the second case, United States versus Bennett, under advisement, Madam Clerk. Call the third case.
I'd like to note that there's a. Go ahead, sir. Sorry.
I was just going to say that's the bankruptcy case, Siegel versus Fitzgerald. And we got Mr. Sandberg and Mr. Kane. But anyway, you're ready to hit, Madam Clerk.
Yes, and there is a rebuttal for the appellee because it's a cross appeal. Mr. Sandberg, whenever you're ready.
Good afternoon. May it please the court. I'm Jeff Sandberg for the United States and the U.S. trustee. Debtors in Chapter 11 bankruptcy cases are required to pay quarterly fees to fund the federal bankruptcy system, according to a statutory fee formula. The question here is whether the liquidating trustee for these debtors is excused on constitutional grounds from paying the fees required by Congress in a 2017 amendment to the fee formula for future quarters beginning in 2018. In bringing the dispute, the liquidating trustee has raised two sets of claims, one involving retroactivity and one involving uniformity. I'd like to begin where we think the bankruptcy court was mistaken, which was its ruling that the 2017 fee amendment is non-uniform. And for structuring that conversation, I think a roadmap or menu of options may be helpful. So I'd like to just quickly list the four grounds on which the uniformity claim fails, and then I'd be happy to discuss any or all of them in more detail. First, the uniformity requirement, there's no uniformity requirement that applies here at all. This case involves a user fee, not a duty, impost, or excise. So the uniformity provision of the taxing and spending clause does not apply. And then the term uniform in the bankruptcy clause applies to substantive bankruptcy laws that alter debtor-creditor relations and not to auxiliary laws that set up the machinery of the bankruptcy system, like the quarterly fee statute here. Second, and this is the ground the Fifth Circuit recently relied on in upholding the constitutionality of the 2017 amendment against a parallel challenge, even if a uniformity condition applies to the quarterly fee statute, no one here has disputed that Congress acted within its authority in setting up the U.S. trustee program, and then in deferring to local judicial preference in certain bankruptcy administrator districts as to whether to opt in to the U.S. trustee program. And once you accept, as I think the liquidating trustee does, that it's fine to have these two programs, there's no problem with Congress funding each one separately and even potentially setting different fees within each program to meet the needs of each. Again, that's the rationale in which the Fifth Circuit relied on in Buffets. Third, even if you thought that uniformity required the fees to be equal across the two programs, that's actually what Congress provided for here. For decades, Congress has specified that the quarterly fees in the bankruptcy administrator districts, those being the districts in Alabama and North Carolina, are to be equal to those in U.S. trustee districts. And that's how everyone, including the bankruptcy administrator districts, had understood and applied the law since 2000. The fact that there was a difference in the implementation of one of the fee changes in 2017 doesn't change the fact that the laws were uniform on their face. And fourth and finally, even if there were a constitutional problem with the non-uniform application in this case, the remedy would not be to order that the debtors don't have to pay their statutorily required fees. The liquidating trustee here is essentially complaining that the statute was correctly applied to them, and there are other debtors elsewhere who are given an undeserved windfall, an unexplained break by the bankruptcy administrator districts. Even if that's true, that doesn't mean these debtors are entitled to the same undeserved break. Congress was clear about what uniform fee schedule it wanted, and under Supreme Court precedent, that controls the question of whether there's any remedy available for these debtors. It's just like the Morales-Santana case where the Supreme Court said, yes, there's a problem with treating the children of unwed mothers different than the children of unwed fathers, but this particular person does not get a remedy because the right result is to eliminate special treatment for children of unwed mothers. With that, I'd be happy to address any of those uniformity grounds in more detail or turn to the retroactivity issue if the court would prefer.
I have this, Judge Quattlebaum. I have some questions on the uniformity issue. Is there, maybe this isn't being advanced, but is there anything about North Carolina and Alabama as a state that justifies having a entirely different system of administration than the other 48 states?
Your Honor, it's not to my knowledge. The liquidating trustee hasn't argued that there's a constitutional defect with that, but the explanation I would give is it's a creature of local judicial preference, just as the fact that this court doesn't have a bankruptcy appellate panel, but the 1st, the 6th, the 8th, the 9th, the 10th, those circuits have chosen to create one. That was because Congress there also enacted a statute that said if the judges of those circuits want to have a panel, they can have a panel. Here, Congress enacted a statute in the 1980s that said, Alabama and North Carolina can opt into the U.S. trustee program anytime, and they haven't pulled the trigger to do that. So it's a difference to local judicial preference.
The example you gave, as I understand it here, Alabama and North Carolina, have an option to opt in, but no one else has an option to opt in. And in the example you gave, everyone had the option about having a bankruptcy appellate counsel. Isn't that right?
That's right. I don't think there's a difference in the constitutional analysis based on that fact. I mean, it's uncontroversial that each local district can have local bankruptcy rules. And indeed, we can have different federal judicial districts to begin with and different circuits to begin with. And if the substantive bankruptcy law is uniform, it's fine to have variations in the procedural trappings of that. And
yeah, but this is, I mean, you're making it sound like it's a little minor issue. I mean, you're talking about a substantial economic difference that a debtor has in every state in the union other than North Carolina and Alabama. And the only reason, it seems to me, is related to geography, that the laws of that those two states elected not to opt in, and they were given that right different than the rest of the states. And I guess more importantly, it's really not part of it's a debtor issue, but isn't it really a creditor issue? Because those amounts that, increased amounts are amounts that don't go to the creditors, in particular the unsecured creditors.
I think all of what you've said is correct, Judge Quattlebaum, but for two reasons, it just doesn't get you anywhere in this case. First, the liquidating trust, we treat Congress's handiwork as constitutional, right? We presume statutes to be unconstitutional, and no one who has standing in this case is before you saying that it's unconstitutional that Alabama and North Carolina have a different system of bankruptcy administration. That claim is not before you. So if you accept, as the Fifth Circuit did, the premise that it's constitutional to have broken off Alabama and North Carolina into a different system, then the question is, does Congress act uniformly in setting the same fee within each system? And the answer to that is yes. And the second important thing to realize is Congress did not actually intend for Alabama and North Carolina to have different fee rates. Congress said that if you can fight about whether the statute is permissive or mandatory, but one thing is clear, if fees are going to be charged in bankruptcy administrator districts as they have been since 2000, they have to be equal to the fees under A6. And they weren't for this, starting January 1st, 2018, the fees weren't equal and Congress did not allow that. So there's not that might be a statutory problem. And you know, it's concerning when there's a large fee increase that takes effect in some districts and not others. But if that's a problem, it's a statutory problem. It's not a constitutional problem because Congress didn't permit it.
Is it on that issue? Is the permissive aspect, however, what allows that? Because here, you know, I realize one issue is the delay from January to September, October. But beyond that, you have the fact that in the trustee districts, it applies to existing cases, and in the bankruptcy administrator districts, it only applies to new cases. Doesn't that kind of indicate that the permissive versus mandatory action creates a uniformity problem?
I don't think that's right, Your Honor. There's nothing in the statutory text that says, you know, the judicial conference at its discretion may, you know, choose not to apply fee increases to pending cases or can delay the implementation by any length of time. I mean, what's particularly curious is the judicial conference, when the statute was first enacted, everybody understood that when A7 was enacted, which is what says the bankruptcy administrators may charge fees equal to, everyone understood that the purpose of that was to solve any conceivable uniformity problem with the statute. Everybody had the intention that the bankruptcy administrator districts were going to start charging equal fees right then and there. And so in 2001, the judicial conference issued an order that specifically directed the bankruptcy administrative districts to impose fees in the amount specified in A6 as those amounts may be amended from time to time. And you know, the bankruptcy administrative districts did that in subsequent fee increases enacted by Congress. It's not clear why they didn't do that in 2018, but even when they acted in 2018 and made it applicable only, you know, for new cases in October 1st, they then said, okay, and we want this to be effective for any, quote, future extensions to that or similar authority, end quote. So again, the judicial conference was saying, we think, you know, we need to be in lockstep with what the U.S. trustee program districts are doing. And it's not clear. There were no findings made by the judicial conference. They acted on an expedited basis. Actually, the executive committee of the judicial conference acted on an expedited basis at the request of a subcommittee to impose this. And so, you know, I haven't seen a principled explanation for why it can be laid at Congress's feet for this non-uniform implementation that happened in 2018.
Where's the authority to your argument that if it's the issue of substantive versus auxiliary? I understand that concept conceptually. What's the best case you have that would indicate that, you know, number one, this is not substantive, something that affects the creditors in this way, and number two, if it's not, that it's exempt from the uniformity requirement? Could you give me the best authority you have on that?
Yes, and with the indulgence, I have kind of two ways I want to answer that, because I don't have a single smoking gun to point you toward. The first thing I'd point you to is the Supreme Court's decision, fairly recent, within the past couple decades, I think, in Central Virginia Community College versus Katz, that looked to the history of the bankruptcy clause. And the Supreme Court said that the bankruptcy clause is unique among constitutional provisions in that it itself waives state sovereign immunity. Usually if a state's sovereign immunity is going to be waived, Congress has to pass a statute and be very clear that that's what it's doing. But the Supreme Court actually held that the bankruptcy clause itself waives state sovereign immunity and looked to the fact that it contained the uniformity provision. The Supreme Court explained that the uniformity provision is an affirmative grant of power to Congress to override inconsistent state laws. But along the way, the Supreme Court said, look, just because a law has to do with the bankruptcy system in some way doesn't necessarily mean that it waives state sovereign immunity. There's a core here, a core of substantive bankruptcy law that waives state sovereign immunity, but it's not that anything that has to do with bankruptcy or has the word bankruptcy slapped on it would do so. And so the Supreme Court has rejected, I realize that's a slightly different context because it's state sovereign immunity, but has realized that there is a core substantive power where Congress has tremendous power, although it has to be uniform. And then there's the auxiliary stuff. The other way I'd like to respond to Your Honor's question is to just point out that we're interpreting this constitutional provision in the context of Article 1, Section 8 as a whole. And if you run down the list of all the clauses there, you see a long list of substantive powers that Congress has. It can regulate commerce, it can, regulate the armies and the navies. All of these things are substantive powers to do things. And if Congress sees fit to establish an administrative regime to help regulate commerce, for example, and wants to charge a user fee as part of that regime, all of that rests on the necessary and proper clause, which provides Congress the kind of nitty-gritty tools to work out the details of a regime. And our submission is that the bankruptcy clause works just the same way. Congress has substantive power to displace state law regulating creditor-debtor relations when you're dealing with insolvent debtors or non-paying debtors for whatever reason. And Congress has power under the necessary and proper clause to set up the trappings of that regime. And there's no reason to read the substantive power in the bankruptcy clause any differently in terms of the substantive procedural distinction than any of the other constitutional powers in Article 1, Clause Section 8. And what's important about this, the Fifth Circuit didn't resolve this issue and skipped ahead to the second ground. And as my adversary is likely to point out, many of the bankruptcy courts that have looked at this issue and said, well, quarterly fees have to do with bankruptcy and it's a lot of money. So why wouldn't we say that it's it's a substantive bankruptcy law or say it's a law on the subject of bankruptcies? But there's lots of other stuff that Congress has authorized, like bankruptcy appellate panels from one circuit to the next, that it's hard to see, how they would be constitutional if auxiliary laws aren't exempt from the uniformity requirement. And this court specifically chose not to adopt a bankruptcy appellate panel in 1995 because it found it would result in, quote, increased costs to litigants. So this court itself thought that the bankruptcy appellate panel was more costly. And so, the analogy here to the big quarterly fee statute seems pretty strong to me, frankly, that you've got, for some length of time, there's a higher fee schedule in place for bankruptcy administration in some districts than others. I don't think that was Congress's choice to do so, but be that as it may, it's like the bankruptcy appellate panels circuit. Congress provided for a regime in which for these auxiliary matters, there's some deference to local judicial preference, and no one has ever thought that to be unconstitutional.
Did you argue the case in the Fifth Circuit?
I did.
And is there also one in the Second Circuit?
That's right. There was an argument in the Second Circuit by co-counsel about 6 weeks ago, I think.
You didn't argue that one?
That's right.
So you're going all around the country with this.
It's become a bit of a cottage industry, Your Honor. After the Buffets case, which was the Fifth Circuit case.
If we disagree with you, we'd be creating a circuit split. Is that where it is right now?
That's right. I think the easiest way to dispose of this would be to agree with the Fifth Circuit's reasoning, in which case there would be no circuit split.
And the Second Circuit, they're still pending.
That's right.
Are there others awaiting argument?
There are cases being briefed in the 10th and 11th circuits. I don't think any other are ripe for argument yet.
Okay, but there's a split among the bankruptcy courts with slightly favoring your position. Is that right?
On the uniformity issue, that's right. And then also on the retroactivity issue, there was a split that was even more lopsided in the government's favor.
Okay, you're winning the retroactivity more solidly than you are the uniformity.
That's right.
Okay. And they've all skipped the district courts, right, and go to the courts of appeals.
Most of them have. There's one case in, I'm forgetting which district now, and in which it's going to the district court first, a case called SCI Direct. But for the most part, litigants have recognized that this is a novel question. It deserves careful attention from, appellate minds.
And the final analysis, the Supreme Court may well have to resolve it, right?
It may if there's a circuit split, although we believe that it's clear enough that the government should prevail here that we don't need to go there. But
go ahead. I didn't mean to get you off track there.
Oh, sorry. Well, if your honors would like to hear about the retroactivity issue, I'd be happy to speak to it. But I also had saved 4 minutes for rebuttal, and I'd be happy to speak to it then. So I just don't want to eat up too much of my rebuttal time now.
Why don't you sum it up there? I'd like to hear it.
Okay. Well, to sum it up, the Supreme Court has been very clear about how you work through a retroactivity analysis. The first thing you do is figure out whether Congress, expressly said when and to whom a statutory change should apply. And we think that Congress was totally clear here. The statute says that you pay a quarterly fee in each case, and for each quarter that the case remains pending. That's the language of 1930 A6. And then Congress popped in 2017 and said, I'm going to amend that fee schedule in A6, and that amended schedule will start in the first calendar quarter after this law is enacted, and that would be the calendar quarter starting January 1st, 2018. So Congress has said, right there, all these cases in which quarterly fees are being paid, there's a new schedule effective January 1, 2018, and you don't need to think hard about whether this would be retroactive or prospective. But even if you do get to the question of whether this would be a retroactive or prospective application, it is prospective because it is a change in fees to be paid in future quarters. Just like a post-confirmation bankruptcy debtor isn't immune from paying an increase in, say, property taxes, or isn't immune from new regulations that might come down in their industry, they're not immune from any increases in fees that Congress might impose. And the fact that they may have had an expectation in 2010 that 10 years when this plan was confirmed that 8 years down the road their fees would be X rather than X plus Y isn't a reason that the statute is retroactive. And with that, I'd like to save whatever remaining time I have for rebuttal.
Very good, sir. And let's Judge Traxler or Judge Quattlebaum have a question.
No questions.
No more questions.
Mr. Kane, you're going to clear all this up for us?
Yeah. Thank you very much, Your Honors. It's a pleasure to be with you today.
Good to have you with us, sir.
I appreciate it. Thank you. I'm going to address the issues in the same order as Mr. Sandberg, but then I'm going to hope to spend a little more time on retroactivity. Starting with uniformity, it is clear that, as Judge Quattlebaum pointed out, there was not uniformity here. There was a different fee schedule until October 1 of 2018 in the bankruptcy administrator districts than there was in the trustee district. And so the government is attempting not to argue that it wasn't uniform, but it's okay that it was uniform. And I want us to understand that what the government is attempting to rationalize is an 833% increase in the fee. And this fee hurts creditors at the bottom line. Again, as Judge Quattlebaum pointed out, and I'm going to spend quite a bit of time on in my argument, those who are injured by the increased fees are not the debtors that chose to file the bankruptcies to begin with, but they are the creditors who are dragged into these bankruptcies. And in a typical bankruptcy context, you have secured creditors, lien holders, lenders, and the like, who generally get paid. And then you have the unsecured creditors who, if they're lucky in many of these cases, don't even get 10 cents on the dollar. And so if you are going to allow different fees in different parts of the country, those creditors are going to be treated differently depending upon where the bankruptcy takes place. And that seems inherently unfair on its face. The justification suggested by the government is that this is all an administrative process through the United States trustee system. And so it's okay for us to have different fees. But those of us who have participated in the Chapter 11 process can tell you that the U.S. trustee is not merely an administrator. As the Ninth Circuit explained in the San Angelo decision, the United States trustee is actively involved in the bankruptcy process, including on many substantive issues, whether a trustee should be appointed or not, whether a case should be dismissed or not, whether there should be fee examiners, objecting to fees itself. The United States trustee system is not simply a procedural system. And so the fees charged for that system, I think, are inappropriately characterized as procedural or as user fees. And so we have clearly non-uniformity before October 1, 2018, that is going to ultimately cost the liquidating trust here $800,000 more if the government's position is adopted. And that's just not right. It is not
Counsel,
permitted.
Counsel, let me interrupt you if I may. This is just Quattlebaum. If you could frame the exact challenge you made, your colleague pointed out or argued or said that you're not really changing the fact that we have two different bankruptcy systems. Your challenge is more narrow than that. I guess, it's the narrowness relates to this specific fee issue. And I understand that's the impetus of this, but doesn't this really derive from the fact that we have two separate systems here and they just operate differently?
Yes, Your Honor. The argument was first fully flushed out in the Buffet's decision by the Fifth Circuit. We're not arguing Congress couldn't set up these two different systems. Personally, I don't think it makes a lot of sense. But if you're going to have two different systems, you shouldn't penalize the creditors who are ultimately looking for some recovery out of these systems based on a different fee schedule. And if you take the government's argument to its logical extreme, you could charge thousands of percents more in one system than you do in another system. And that would still be constitutional. And that's going to be the same argument you're going to hear from me on retroactivity. They want a blank check. And they want a blank check in order to fund a system going forward. And yet they're asking, in this case, the Circuit City Liquidating Trust, which, as I'll explain in a minute, doesn't even use the U.S. trustee system anymore, to pay for a large deficit that the U.S. trustee system has been accumulating over a number of years. And I'm going to argue when I get to retroactivity, I don't think that's what Congress intended. So the system.
What's your argument on the remedy? Your colleague said that even if it were to lose on all three of those issues, and even if there's a constitutional problem, you shouldn't get the remedy of reduced fees because I think what he's saying is that the bankruptcy BA state should have the same fees as A6 allows.
Your Honor, we're not asking to pay nothing. We're asking for the old schedule to apply through October 1 of 2018. And that's an $800,000 difference.
Because the point is, I guess, the point is if A6's new schedule is non-uniform, then it's improper under the Constitution, and you should have the old schedule. That's the way the logic goes.
That's correct. We're not asking to pay nothing. We're asking to go back to the old schedule where the United States trustee fee was relatively administrative, no more than $30,000 a quarter. Now it could be $250,000 a quarter. Unless there are other questions, I'd like to move to retroactivity.
Move right along there to retroactivity. That'd be good.
Thank you. Judge Hennekins, in his decision in the bankruptcy court, noted that Congress did not expressly prescribe that the 2018 amendment would apply retroactively. And counsel argues otherwise, but if all we need to do is look back to the prior situation.
This is Sarah, the conference manager. I'm sorry to interrupt, Mr. Kane. You're going in and out. Can you speak as clearly as possible? It's just getting worse.
Oh, I'm sorry. Yes, and please interrupt again if I can plug in a microphone if that would be more helpful.
You can try that if you like. Yes.
Go back to where you started on retroactivity. That's where you started breaking up.
Right. Okay. Is this better? Can you hear me better now?
It seems to be. Just go ahead and try.
Okay. I'm using a microphone, so hopefully that will be better. As Judge Hennekins indicated in his decision, Congress did not expressly provide for retroactive application here. If we look back to the last time it passed legislation on fees in 1996 and 1997, which was involved in the H. Robbins decision, there was a question as to whether it applied to prior cases, and Congress had to go back and say, yes, it does apply to cases that had been filed prior to the applicable date, even if they were confirmed. Congress didn't do that in the 2018 amendment, as Judge Hennekins points out. So since it's not clear that this is to be applied retroactively or not, then we need to turn to Landgraf to decide whether or not it should have retroactive effect. And I'm going to refer specifically to one provision of the Landgraf quote, which asks whether it imposes new duties with respect to transactions that have already been completed. And I want to spend a little time talking about what happens before confirmation of a plan. So hopefully I can convince your honors that this is a transaction that was already completed and that rights have already been set in stone prior to the changing of this amendment, so that it should not be applied retroactively. When parties get together to try to negotiate a plan of reorganization, there is generally a debtor which is operating or hoping to continue to operate, negotiating with creditors of all kinds, whether they're lien holders with security interests or unsecured creditors or many other constituents, in order to try to determine whether an arrangement can be made so that the debtors can continue to operate even if they don't pay all creditors in full. Now, these negotiations are often very charged and hotly contested. And by the time we get to a plan, an agreement has often been forged among all these constituents that is going to lock their rights in stone after the confirmation of a plan. And once those rights are locked, it signifies that all those creditors have agreed that they are going to abide by the plan, and in understanding how to make that decision, they are operating based on projections as to how much they're going to get paid. And as I mentioned earlier, for general unsecured creditors, that is often less than 10 cents on the dollar. So rights have already been fixed when a plan is confirmed. And that's what section 1141 of the Bankruptcy Code provides. It's the effect of confirmation is to create a contract that vests substantive property rights on all parties, whether or not they voted for the plan. In the Circuit City case.
Mr. Kane, let me interrupt
Yes.
you just a sec. Mr. Kane, this is
Sure.
Judge Traxler. In describing the expectations of the parties when they enter into a plan, how would the assessment of these fees differ from a new tax that was imposed after the plan was agreed on?
Judge Traxler, this is the analogy that I would try to create. Once a plan is confirmed and creditors know more or less what their recoveries are going to be, to implement a new tax of an amount that, according to the government, could be any amount. It doesn't matter. It would be constitutional no matter what, is akin to somebody going into a post office and paying the money to mail their package. The package is taken by the clerk, and then on their way out, they're asked to pay some more. They didn't, on their way in, know exactly what they were going to pay. And then they were asked to pay more on the way out. And again, I think it's important to recognize that those hurt here are the creditors. Not generally.
I'm sorry to interrupt you, Mr. Kane, but your position would be that if this were a tax, it would also be unconstitutional.
I'm hesitating to answer your question, Your Honor, because.
That's okay. I hesitated to ask it.
I appreciate that. It's characterized here as a user fee. And what I want the panel to understand is that the creditors who are being penalized by this increased fee are, yes, participating in the system, but they didn't start it voluntarily. And also what I want the panel to understand is that the U.S. trustee's involvement in a Chapter 11 case is generally at the beginning and pre-confirmation. Once a plan is confirmed, there is very little, if any, involvement of the United States trustee other than in collecting fees. A quarterly report is filed by a post-confirmation estate, and the trustee sees how much the fee should be under the prior schedule, up to $30,000 a quarter. So there isn't really using of the system by a post-confirmation bankruptcy estate, because the U.S. trustee is really not involved at that point. So it is particularly unfair to apply this increased schedule to a large post-confirmation liquidating estate, asking it to pay for the operation of a United States trustee system that it's not availing itself of. And
Mr. Kane,
yes.
Mr. Kane, let me ask one question. If circumstances, be they related to a fee increase like this or some other circumstance related to the way in which the debtor is rehabilitating, is there an opportunity under the bankruptcy code to move for a modification of the plan, yet to adjust payments, either in amount or the time that the payments are due, to adjust for economic changes like it might come about?
As a practical matter, no, Your Honor.
I actually did some bankruptcy a while back, and I'm losing my memory maybe more than I'd like to admit, but I remember like motions to modify plans and things like that. Am I just not remembering correctly that was a procedural vehicle that you could utilize under the bankruptcy code?
The statute provides for the ability to modify a plan, but you're not going to be able to modify the shares in a smaller pool of resources through modification of a plan. So when the confirmation agreement is reached, there's generally an understanding that secured creditors are going to take X%, and they're going to leave a certain amount of money for general unsecured creditors if they're taking a haircut on their own. It's a modification of the priority and payment system. And to go back and modify a plan to change that on behalf of unsecured creditors because they're getting hurt by an exponential increase in a U.S. trustee fee, I think that's dead in the water.
Okay. I think I heard your bell go off, Mr. Kane.
Yes, it did, Your Honors. Thank you.
But you say you got some time saved. And now,
Yes,
Mr. Sandberg, we'll go back to you again.
Yes, thank you, Your Honor. Just one quick point on retroactivity before I switch back to uniformity. It really can't be right that what's in the creditors' minds in 2010 should control what fees they have to pay down the road. And one really good example of that is in 2010, the creditors thought that this liquidating trustee was going to wrap up after 5 years. The liquidating trust was authorized for 5 years. And it was only because the trustee sought further extensions, and I'm sure, there were circumstances outside the trustee's control that contributed to that, but it was only because of the multiple extensions for liquidating Circuit City that we ended up in a situation where this increased fee applied to them at all. And, anybody who participates in bankruptcy knows that at a certain point, to keep the case open, to keep litigating, there are trade-offs. You have to keep paying quarterly fees if the case is still open. And if there's not much chance of recovering on the remaining claims, you just close the case. So it can't be right, for lots of reasons, but including that the liquidating trustee himself, decided that the creditor should have to keep paying quarterly fees by keeping the case open past the original 5-year period. On uniformity, I didn't really understand my colleague's answer to the remedy question that was asked. My colleague said, well, we're not saying we don't have to pay any fees. They're saying we just want to pay the reduced fees. But the remedial question is, what would the uniform fee schedule look like that Congress would intend? And I think everybody agrees Congress intended the bankruptcy system to be paid for by users rather than by taxpayers. And the remedy that my opposing colleague is suggesting is that the fee increase that Congress put in place to keep it a user-funded system should be disregarded, and that taxpayers should be on the hook for the increased fees necessary in order to maintain the bankruptcy administrator system. And that's clearly not what Congress intended. And following in the Morales-Santana remedial analysis, which my opposing colleague didn't even brief, I think you could resolve that case on that independent grounds alone. His suggestion that our understanding of the uniformity provision of the bankruptcy clause would allow Congress to impose, a 1,000% fee increase in only one state and not another, isn't right. I mean, you have to we're arguing that the court should be turning square constitutional corners here, and that it's not the uniformity condition of the bankruptcy clause that would provide a check on that sort of law. But the Supreme Court has repeatedly said that a law fails under the due process clause if it's imposed for an arbitrary and irrational reason. Congress isn't allowed to throw darts at the wall and deciding, which debtors have to pay millions of dollars of fees and which don't. It has to be rationally related to what Congress is doing. But here they haven't disputed that it's constitutional to have two different systems. And once you accept that premise, it is rational to have one fee that applies uniformly in the U.S. trustee program and another fee that applies uniformly in the bankruptcy administrator program. Of course, our further submission is Congress provided for that same fee to be equal across the two programs, and it's just that there was a lag in the implementation in one of them. But be that as it's may, Congress would have the authority in the first place to set up a different fee in the U.S. trustee program if it wanted to, and that's the logic of the Fifth Circuit's ruling. The last thing I want to point out is yes, of course, the U.S. trustee program is actively involved in managing bankruptcy cases, particularly at the start and pre-confirmation, but it also plays a role in many post-confirmation cases. But the bankruptcy administrator program performs the same exact role. That's not a distinction that has any bearing here on whether this is a law on the subject of bankruptcies or not. I mean, it's not as though only the U.S. trustee program is performing the functions that my opposing counsel referred to. So just as the courts across the country are playing a really important role, but similarly, the law is setting up the machinery of the courts, we think is non-substantive and therefore doesn't implicate the uniformity provision of the bankruptcy clause. If there are no further questions, I would ask that the court reverse the uniformity ruling, but otherwise affirm.
Any further questions for Mr. Sandberg?
None from me.
Me either, thanks.
Very good. Thank you, Mr. Sandberg. Appreciate it. Mr. Kane?
Yes, thank you very much, Your Honor. Addressing first Mr. Sandberg's comments, it is true that the liquidating trustee in this case has requested multiple extensions of the term of the trust, and he did so in every instance to enable creditors to recover as much as possible. And in fact, the liquidating trustee in the Circuit City case has done very well in litigation and has recovered 55% for general unsecured creditors. So by all references, it's a very successful case. But it's not right to put the liquidating trustee to a decision to stop litigation in order to avoid paying fees. He made the decision to extend the trust, knowing that along the way, the fee paid to the U.S. trustee system would be relatively nominal at $30,000 maximum per quarter. And so to change that to $250,000 maximum per quarter is an imposition on unsecured creditors that is not rational. The argument that if there are two systems per se, different treatment in those systems is rational is a non sequitur. How is it fair to creditors in Virginia or any other state besides North Carolina and Alabama to have them get less money out of what would otherwise be the same bankruptcy system? It's not uniform, and it shouldn't be allowed to penalize creditors.
Thank you, Mr. Kane.
Yes, may I address retroactivity?
Well, oh, sure, you go right ahead. Yeah, I thought you paused there, and I thought you were wrapping it up. No, you go ahead.
Thank you. I speak slowly sometimes, Your Honor. The Fifth Circuit in Buffets, which of course we hope you decide differently from, addressed the retroactivity question by asking whether the amendment's negative effects on debtors stem from events completed before the enactment of the law. And it concluded not. But the liquidating trust is hoping that Your Honors will decide that in fact, all of these events were completed in the confirmation of this case in 2010. And that the parties whose rights were fixed, the creditors, are the ones who are harmed by what is now clearly retroactive application of this fee increase. The legislative history around the 2018 amendment indicates that is intended to address deficits in the U.S. trustee program based on activity going forward. And so to ask creditors of Circuit City to pay for deficits that occurred prior to the 2018 amendment at a time when they're not using the U.S. trustee system and they're only paying fees is a retroactive application that impairs the rights of parties whose rights have already been fixed. And so we are asking this panel to focus on creditors and not on debtors, which virtually every court has up to this point in time when assessing whether this is a retroactive impairment of rights, and we suggest that it is. And so based on retroactivity and based on non-uniformity, we ask the panel to strike down the fee statute as unconstitutional.
Do you want us to sustain the ruling of the bankruptcy court?
I would like you to sustain the ruling of the bankruptcy court that it is unconstitutional as not uniform, but also overturn the ruling of the bankruptcy court that it is not retroactively unconstitutional. That's why there's a cross appeal here.
I'm with you. Okay.
Thank you very
Any
much.
other questions?
Not from me.
No questions.
Madam Clerk, we appreciate council's participation remotely, and this case will be taken under advisement, and we can adjourn court for the day, and you can put the panel into conference, however you do that.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Judges, I'm going to